All right, so let's talk about liability. Let's talk about federal court and liability in federal court. So back in 1979, Congress passed Chapter 42 U.S. Code Section 1983, which creates civil liability and a cause of action for the deprivation of rights. Specifically, it creates a cause of action should a police officer deprive someone of a right or privilege or immunity that is secured by the Constitution. Okay? Now, of course, there's going to be a lot of exceptions to this, but the big one is what's referred to as qualified immunity. So then back in 1982, the case of Harlow versus Fitzgerald came into existence that established qualified immunity for government employees that were the subject of a claim for civil damages, all right? And throughout the history of civil rights litigation, what the courts have adopted is a standard where qualified immunity has been recognized to protect all but the plainly incompetent or those who knowingly violate the law. And that's actually a pretty hard standard to meet. However, you have to just be conscientious that as long as you have a good faith basis for the actions that you take, you're not going to be held liable under Section 1983. So as long as you're acting in a manner that is reasonable, objectively reasonable, and as long as you're acting with good faith, and as long as you are acting in the course and scope of your employment as a police officer, a Section 1983 claim is never going to proceed against you personally. So that is a very rigorous standard, which is why you actually don't see so many federal lawsuits against police officers, because your conduct has to be very egregious, and it has to violate an objective reasonableness standard. And there's also certain other calculus that goes into it as far as department policy and procedure, and whether or not a policy or procedure was employed by the department to make you do something that was unconstitutional, that the department knew to be unconstitutional, and they would have to prove that to create the liability on the part of the department, which every department I know employs lawyers who do nothing but review the constitutional impact of the actions of the police department. So don't be too concerned about how liability is going to confront you in a federal civil rights claim. Your conduct really does have to be objectively unreasonable, and it has to be, well, but just plainly incompetent, and it has to be based on you knowingly violating the law. And as long as you don't do those things, well, you're simply going to be clear from that kind of liability in federal court. And so don't get too preoccupied in the decisions that you make as a police officer, where you become so apprehensive about getting sued that you wind up making a mistake that gets you killed, because that is my number one concern, is officers getting injured or killed, especially in the course and scope of their employment as police officers. To not be so scared in protecting yourself that you wind up allowing yourself to be hurt. Texas Penal Code Section 9.31, self-defense. A person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. Now, this unlawful force includes force to inflict serious bodily injury or death. And as we know, you have the right to use deadly force to defend yourself when you fear serious bodily injury. You don't simply have to be in fear of death to use deadly force to protect yourself. And so that's going to apply both criminally and civilly. It's important to remember that you do have a job to do. And that job is going to be a violent job sometimes, and it's going to be an ugly job sometimes. And you should not allow yourself to be too anxious about the public's reaction when you're simply trying to survive a violent encounter. Sometimes you got to put all that out of your head and just survive the encounter. And so, as long as you are objectively reasonable, as long as you're acting in good faith, as long as you're not employing excessive force in a manner that would be objectively unreasonable, which is a pretty high standard, you're going to be okay. Don't be too anxious about it. Make sure you survive the encounter. All right? It's important that both in state law and federal law, there are numerous exceptions, immunities, and exemptions that do protect you. It's just a matter of reading the law. And unfortunately, sometimes lawyers that work for counties and cities will confuse you as the officer as to what you can be sued for. And sometimes instructors might overstep and try to tell you or convince you that you're going to be liable for things you're not going to be liable for. If you have a question, just read the law yourself. That's all you have to do. You're going to find that in, like we've discussed, Chapter 42 of the United States Code. You're going to find it in the Texas Civil Practices and Remedies Code. You're going to find provisions regarding self-defense in the Texas Penal Code. Just be aware of what these laws are. And if you understand them, and if you apply them reasonably, and if you're acting in good faith, you're going to be fine. And you're going to go home alive at the end of the shift. All right, thank you.